Does qualified immunity actually accomplish what the Supreme Court intended? I'm Kim Norberg of the nonprofit civil liberties law firm Institute for Justice, joined by co-host Keith Neely. And today we're going to discuss qualified immunity by the numbers and how it plays out in the real world. We're joined by IJ Senior Attorney Bob McNamara and data scientist Jason Tiezzi. This is Beyond the Brief. So, guys, just briefly, what is qualified immunity?
So qualified immunity is a doctrine created by the Supreme Court that basically says government officials who violate the Constitution can only be held liable if they violated what's called a clearly established right, which in practice basically means you have to be able to point to a court decision that says doing exactly this thing in exactly these circumstances violated the Constitution, and only then can the government official be held responsible for whatever they've done.
Bob, at the outset here, it might be worth distinguishing qualified immunity cases from the sorts of other cases that IJ has been litigating, because I'm sure some longtime IJ fans are wondering to themselves, IJ has been successfully suing the government now for 30 years, but I haven't heard about the problem of qualified immunity until recently. So what distinguishes these sorts of qualified immunity cases from what I'll call the traditional IJ case, where maybe we're suing about an economic regulation or we're getting involved in civil forfeiture?
It's mostly a question of timing. So in a lot of IJ's cases, we're suing about what's going to happen tomorrow. We say there's this unconstitutional law in the books. We want you to stop enforcing it against us now so that we can go out and start our business tomorrow. We can go out and speak freely tomorrow. But one thing we discovered as we litigated these cases is that sometimes all of the unconstitutional harm is in the past. We would sue about an asset forfeiture, and the government would instantly give the property back in the hopes of making us go away because we're terrifying. And it turns out that if what you're talking about is the past, you say you violated the Constitution yesterday, and I want you to make me whole for that. I want you to pay damages for what you've done. The court says, well, then you have to get past qualified immunity. Then, well, if we're talking about tomorrow, all that matters is whether the Constitution's being violated, and we'll give you an injunction to help you tomorrow. If the government surrenders, if it hands back the property and you want the value you lost from having your property held for so long, that's when they say, well, if you want to hold that person responsible for violating the rules, you need to point to a clearly established right.
So let's jump into the report a little bit. Jason, what is this report about, and how is it sort of different from the other studies in this space?
Yeah, so I think what we really wanted to do here was just describe the landscape of how qualified immunity actually works in the circuit courts. There's been a lot of really great research on qualified immunity that I think we benefited from tremendously in doing this project, but a lot of it's focused a little bit more narrowly. So it'll look at just police cases or police excessive force cases, or answer very specific legal questions about the court's reasoning. There hadn't been as much that's just like very generally, what do qualified immunity cases look like? Who are the defendants? What are the violations that are alleged from the government official or against the government officials? What are some of the procedural issues that come up a lot of times, and how do those shake out? So we really just wanted to describe, what's out there. And that's something that I think certainly in the way we did it hadn't been done quite as broadly before.
So you mentioned police and excessive force, and as this report shows, it's kind of, much broader than that. So tell us kind of some of the numbers and what did we find there?
Yeah, I think, for me, that was very surprising as kind of an outsider coming into this project. I know it was a little less surprising for Bob, who's been involved with qualified immunity for a while. But about a fifth of cases involve no police or no prison defendants. So defendants like mayors, university administrators, just, kind of random government officials. Which, again, that was not what I expected coming in. And then I think also the First Amendment piece was something that really jumped out. The fact that a little bit, just under 1 in 5 qualified immunity appeals involve First Amendment issues really was, I think, very surprising and an important finding as well. That's not something that has come up a lot in the literature about qualified immunity before, or even in just like the general public discussion.
And I think that's really what we're trying to achieve with this report is take a step back from a lot of the shouting about qualified immunity and just answer some basic questions. One thing I've found at my time, and I think IJ has found in a lot of our advocacy, is that the first step in talking about a lot of issues really is just counting. How often is this happening? What kind of rights are being squelched by qualified immunity? Who's getting sued? And when you have those baseline numbers, which at this quantity no one had ever really gathered before, you can start to have a serious conversation about what qualified immunity is actually doing versus what people think qualified immunity is meant to be doing.
The numbers about the First Amendment claims really jumped off the page to me as well. It kind of shattered my expectations about how qualified immunity would be applied in practice. Bob, I'm kind of curious, in the context of these sorts of First Amendment claims, which are in most cases premeditated, how does that square with the Supreme Court's historic rationale for the doctrine of qualified immunity, which in my view, I think seems to be focused less on premeditation and more on this kind of split-second decision-making?
Yes. So when you hear kind of debates about qualified immunity, you hear a lot of talk about how government officials need breathing room, that they're making difficult split-second decisions, and we need to create a space so they can fulfill their duties without worrying that they're going to take a wrong step and end up defendants in a lawsuit. And I think the First Amendment cases in our study are really illustrative of how that works in the real world, because qualified immunity as a doctrine doesn't say we're giving you breathing room for split-second decisions. It says you're protected from liability unless there's an on-point court case that says you're not allowed to do this thing in these circumstances. And it struck us in looking at the numbers how many First Amendment claims there were. And it was so striking, in fact, that we were worried, are these First Amendment claims where someone says, oh, the police officer punched me when he arrested me because I was mouthing off, or are they something else? So we dug deeper and looked at a sample of the First Amendment cases, and over half of them were actually alleging premeditated retaliation, not somebody lost his temper because I mouthed off, but actually long-term plans to retaliate against someone for their protected speech. Cases that look a lot more like a case IJ's litigating right now in East Cleveland, Ohio, where our client, William Farnborough, owned a sound truck that he was using to campaign against the local mayor, and the local mayor sent out the police to actually take the sound truck away. That was not a split-second decision. That was a premeditated attempt to punish people for speaking out against him and actually silence his political opponents by taking their truck. And that gets doctrinally the same kind of qualified immunity protection as someone who loses his temper and punches someone in the nose. And the fact that there are so many cases out there is, I think, striking and is something that proponents of qualified immunity really have to deal with. If this is a doctrine that's supposed to be about split-second decision-making, we should be having a serious conversation about all of these long planned-out retaliatory schemes that are nonetheless getting swallowed up by exactly the same doctrine.
So a lot of the sort of, you mentioned the screaming about qualified immunity. A lot of that kind of centers around police and excessive force, and this report shows that that's, not necessarily the case. The other thing that, people might think about qualified immunity is that it's sort of, depending on who you talk to, that it's, one person wins all the time or somebody else wins all the time, right? So who is winning, quote unquote, these qualified immunity appeals, and what does that look like in different courts?
Yeah, so, generally speaking, defendants or government officials have a lot more success than plaintiffs do by about a 2-to-1 margin. But it looks very different in different parts of the country. So the Fifth Circuit is definitely the least favorable to plaintiffs. I think pretty much any way you measure it. I think they only denied qualified immunity in 16% of appeals that were in our data set in the Fifth Circuit. Contrast that with some of the other circuits where they tend to be, I think, the Fourth and the Sixth in particular, which I don't think, I'm not an attorney, so I don't have a whole lot of preconceived notions of the circuits, but I don't think those would be typically associated as the most plaintiff friendly. But our data showed that those tended to be the ones where plaintiffs had more success. And just overall, I think that was a theme throughout the report, is how much circuit variation there was in even going beyond the outcomes in all sorts of different areas.
One of the other kind of circuit variation issues that caught my eye was how circuits publish their opinions at such different rates. Bob, can you explain a little bit about why the publication rate matters and why it's important when circuits publish, for example, way more opinions than others in the qualified immunity space?
Sure. So it matters a lot because if what you're looking for is a clearly established right, you need a court case that says, again, in these circumstances, you can't do that specific thing. And so you need to find a published court case saying that. And it's one of the odd little fictions of qualified immunity, right? That we imagine government officials are very scrupulously reading all of the published court opinions and are not reading anything else, like their own training manuals. But that is, the courts have said, the only source of clearly established law, the only thing that could put a government official on notice that he's breaking the law is an on-point case from this jurisdiction, which will grant you is just kind of an absurd thing to imagine. But if that's what we're going to imagine, then it turns out your rights depend a lot on how many published court opinions you have to choose from. How many constitutional cases does your circuit decide? How often do they publish them? How often are they published binding precedential opinions? How often do they actually resolve constitutional issues? And so your rights end up ratcheting up or down based in part just on where you are in the country and how active the federal appellate court is in that region.
And just to follow up, too, I think the publication data also jumped out at me because of how just dramatically divergent the circuits are. I mean, I think the First Circuit's like in the mid-80s in terms of its publication rate, whereas the 11th is like in the teens. I mean, that's a huge difference. And so in the report, we actually compare to Patrick and Anya had done another study for IJ that looked at the amount of clearly established law, and you can really see the impact that actually has. Because some circuits the circuits that have higher publication rates tend to have a lot more clearly established law, as you would expect.
Sure, that makes sense. We had mentioned earlier the Fifth Circuit specifically. IJ has several cases that have come out of the Fifth Circuit that have touched qualified immunity in some way or another. Bob, can you just kind of briefly highlight a few of those?
Sure. I mean, the Fifth Circuit is a large circuit, and so IJ does a lot of work there. But several of our Fifth Circuit cases center around qualified immunity, one of which right now is at the United States Supreme Court. It's another of these First Amendment retaliation cases where our client, Sylvia Gonzalez, was a member of the city council in her hometown. She was at odds with the mayor, as politicians sometimes are, and the mayor, as a scheme to punish his political opponent, arranged to have her arrested on the charge that she had stolen an official government document. And the official government document was a non-binding citizen petition that Sylvia herself had created to advocate for the firing of the town manager. She accidentally put it in her own binder at the end of the meeting, and that, the mayor decided, was a crime. And he engaged in a bunch of procedural chicanery to make sure that she was arrested for this, that she had to be booked and handcuffed in person. He did this by making sure the local district attorney was entirely cut out of the process. As soon as the DA got wind of the charges, he dropped them because it's absurd. But that was a First Amendment retaliation claim, just like we were talking about. We filed in the trial court, and the trial court said, no, this states a First Amendment claim. It's clearly established that you can't do this to your political opponents, which brought up another aspect of qualified immunity that we also touch on in the report, which is qualified immunity gives defendants a special right of appeal. That if ordinarily in litigation, if a defendant says, I want this case thrown out, the complaint doesn't state a claim, and the judge says, no, this states a claim, you have to proceed through the rest of the lawsuit. You don't appeal until the case is over. A qualified immunity defendant gets to appeal right then. They actually have 3 different junctures in the midst of the case when they can file their own appeal. And so the defendants in Sylvia's case filed an appeal to the Fifth Circuit. A panel of the Fifth Circuit said, actually, it is okay to have your political opponents arrested. And that case is now up at the Supreme Court, even though it's still at the pleading stage, in part because qualified immunity gives defendants these tools to kind of drag out litigation by filing appeals that nobody else would get to file.
And Bob, I'm so glad you expressed it in precisely those terms, dragging out litigation. I think intuitively, as lawyers, we've always thought about this special right of interlocutory appeal as delaying the case. But Jason, as part of this study, we actually have some hard numbers we can put to that. What did we find out about the average length of qualified immunity cases when measured against the average length of other civil cases?
Yeah, I mean, basically qualified immunity appeals from more or less the point that the case was filed to the time of the appeal decision have been open about 25%, 23% technically. I'm nerding myself out here with the percentages. Yeah. But they've been open longer is the short story, a considerable amount longer than a typical civil appeal. And it's tough to parse out the exact details, but undoubtedly interlocutory appeals play a role in that because you do, like Bob said, you get multiple bites at the apple, and that I think previous research shows it drags out lawsuits by about a year per interlocutory appeal. So you can imagine how you could end up with a lawsuit that's quite a bit longer. And I think in the report, we have an example of a case that dragged on for 12 years with 3 different interlocutory appeals. And I think really illustrates how damaging interlocutory appeals can be, because no matter how ironclad your case is as a plaintiff, you're going to be disadvantaged by the fact that you have to overcome all of these appeals. Their case was about as ironclad as I could imagine one. It's I think a government administrator basically looted a deceased man's home and auctioned off some of the stuff. I mean, it was egregious, and they won because it was really bad. But it just took them so long to get justice because qualified immunity was in the way.
And the irony of this, right, Bob, is that qualified immunity has always been described as a tool of reducing the cost of litigation for government defendants. But it sounds like, in fact, it's dragging out those cases, and I would assume dragging out the cost of litigating those cases, right?
No, that's exactly right. And that certainly it jibes with kind of our own experience as litigators, that appeals take a long time. And even if there isn't a very good argument the other side has on appeal, it still eats a year out of the case when you can't move forward. And so another justification for qualified immunity, as you say, is we want to protect government officials from the burdens of litigation. But again, what we found was qualified immunity seems to be making cases take a lot longer, and it also seems like it's not doing a great job at protecting defendants from the costs of litigation, because most of these appeals, as we found, are coming up at what's called the summary judgment stage. So there's the motion to dismiss stage where you say, you should just throw this complaint out on its face. You can't bring this lawsuit at all. If the court says, no, they're allowed to bring this lawsuit, that's a free appeal. Then there's summary judgment that says your evidence is so weak we shouldn't even go to trial. And that happens after discovery, after everyone's sat for a deposition, after the sides have exchanged evidence and documents. And if the court says, no, I think we should go to trial, the government defendant gets a right of appeal then too. And those appeals, the ones after all the discovery and the depositions, the summary judgment appeals, are most of the interlocutory appeals you see. So not only are we making the lawsuits longer, but to the extent qualified immunity is seen as a way to sort of quickly parse out cases and make sure government defendants aren't getting deposed, it doesn't seem to be doing that either. The cases are longer and the discovery is happening anyway.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost-efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
So kind of back to the sort of, plaintiffs, I always feel weird actually saying that word, but the, people that are actually suing about this abuse, how can people afford to keep going in these cases that are being drawn out? I mean, IJ, we represent our clients for free. We can do this for forever if the government is going to make us. But for, this guy who, the government raided this deceased man's home and things like that, how do people even have the financial resilience to make this happen?
I think the answer is a lot of people don't. And that's, not only is litigation expensive, but delay is expensive. If I steal $10,000 from you and you have me dead to rights that I've stolen $10,000 from you and you sue me to get your $10,000 back, if I say to you, look, I stole your $10,000, but I can make sure you don't get it back for 3 years, for 5 years, for 10 years. So I'll give you 5. I'll give you 3. that becomes a very attractive offer if you know there's not really a way you're ever going to get in front of a jury for years and years, no matter how good your case is. And that settlement pressure probably makes a lot of cases and a lot of meritorious cases go away before they ever even get to the appellate stage.
So we talked a bit about how, qualified immunity gives defendants special advantages. The other thing that this report found is that qualified immunity is sort of arbitrary and confusing. Can you talk about those aspects a bit?
Yeah, that's definitely one of my favorite words with qualified immunity, arbitrary. I feel like it really well captures how it actually works in practice. So that was sort of an accidental finding almost, where originally we were going to be looking at the rationale for why courts were granting qualified immunity. There's kind of a complicated backstory about, how the court proceeds with its analysis. And the short story is, as we were coding those things, we started realizing, Keith, you can probably speak to this directly because you're one of the coders, that is really hard to parse the court's rationale. A lot of times the courts are really unclear about what they're doing in these qualified immunity appeals. And especially then as we started to look through the literature, it's like, wow, yeah, we're not alone here. There's a lot of other studies that have encountered the exact same issues. And so seeing that was really striking because, one of the kind of underpinnings of qualified immunity is that government officials have clear notice of what is and is not allowed. Well, it's like if our expert attorneys and legal researchers can't make sense of these, like what hope does a police officer have? And not only do they have to make sense of it, then they have to be able to apply it on the fly. So it's almost like it's worse suited for the type of split-second decision-making that, its proponents normally advocate for. So anyway, yeah, we basically just found that it was really hard to code those appeals. I think a quarter of appeals ended up being coded as unclear initially by our coders. And like I said, that wasn't something that was unique to us. That was something that lots of other studies have found too.
Yeah, full disclosure, I did participate in the creation of this study. I did hand code many cases, and I can second Jason's observation that yes, it is incredibly hard sometimes to categorize cases at the level of granularity that we needed to be able to make these sorts of findings. And I'm wondering, Jason, if now might be a good time to talk a little bit about how you were able to use the hand coding in creating a model that you could then use to read these. How many cases was it?
About a little over 7,000
Wow.
was what came from Westlaw.
So how did that process play out?
Yeah, so I mean, one of the things that is a little different about this study, and obviously, I'm a data scientist, it's kind of like, why am I here? Is we used basically predictive algorithms to help us sort through this large body of appeals. I mean, again, Keith can attest to, like, going through these by hand is just incredibly time consuming. I think for all of the hand coding that we did, which we hand coded about 10% of the appeals, it was something like a year and a half, 2 years to get through that whole process. So it was really tedious, really time consuming. So basically, in order to be able to do that efficiently, we built kind of very, I would say, pretty simple algorithms that helped us parse these appeals. And so I think one thing I definitely want to emphasize is, like, this isn't a Chat GPT-like thing where, like, the robot taught itself how to read qualified immunity cases.
I have promised Jason will stop telling people we built a robot that reads cases, but...
Yeah, it's really, at a very high level, what we did is we leveraged the expertise from people like Bob, from people like you, Keith, from Patrick and Anya, and basically translated that into code. Create a lot of times pretty simple rules that look for certain things in the cases that are relevant to the task at hand. And so I guess kind of zooming out to the very big picture, we hand coded about 10% of all the appeals. And then we used that 10% to build the algorithms that we then ran on the whole set of 7,000. And then I think one thing that's really important to emphasize is to make sure it was accurate. What we did at the very end of the process, after everything was said and done, we hand coded 200 extra appeals. And we basically said, we're going to run the algorithm on those appeals. And, the algorithm's never seen them. I've never seen them. And we're going to compare how well the machine does with how well the people do. And then we're going to report those statistics in the study. And generally speaking, the algorithms did pretty good. I mean, I think the humans did win, but it was
That's a relief, for me at least.
But it was pretty close. And I think on some of the fields where we were that we felt like were absolutely critical. So like the First Amendment was one that we obviously were really interested in. Like it performed exceptionally well on that, which we're very thankful for. And the things where it did less well, we really tried to stay away from those in the study. We wanted to be able to talk with confidence about what we found and not, speculate on data that's shaky. So there were some things that weren't quite as good as we anticipated, and so we really didn't spend much time on them. Or in the case of, like, there are certain fields that just never even made it here, where it was like, yeah, this isn't going to be feasible. So.
You talk about the accuracy of the algorithm that we were able to put together. Could you put some numbers on that? Are we talking about, the algorithm was correct 80% of the time on the test sample, or was it closer to 95%, 96%?
Yeah, so I mean, very generally, I think probably like 95% is a good ballpark figure. It gets really technical with some of the details and like how do you measure accuracy? Like, for example, you know what? I'm not going to go there. That's a little, but there's lots of different ways you can measure performance, and accuracy isn't always the best way. But if you're thinking just very generally about how well they did, I think 95% is a good rule of thumb, but it does vary some. So like the First Amendment field, that was about 99. It was over 99% accurate. The publication rates was another really well-performing field. Excessive force was another really good one. So there's some fields that did really well. There are other fields that, like, I think illegal searches, which we don't really spend much time on, definitely didn't do as good. But I think big picture, yeah, I think 95% is a reasonable benchmark of, like, if you're looking at it as a layman.
And I think a nice thing about the report, and I say this kind of having come to it as a Luddite who just sort of told Jason none of this was possible and you can't build a robot that builds cases, is that the report actually contains the accuracy rates for all of these fields, which, as someone who was skeptical of being able to do all of this with a computer, is what was helpful for me. Because when you read studies like this, it's often research that's based on hand coding by law students. And hand coding by law students also has an error rate. We just can't tell you what the error rate is. And so it gives me a lot of comfort that we can actually look at this and say, look, we built this thing. We're highly confident in these findings. We're mostly confident in these findings. And then there are some things that we just can't tell you about these cases.
Yeah, and I think speaking to that point on the hand coding, that was something that was a real challenge for us in the study, was getting good hand coding. I mean, we had to bring in the big guns, like, with our qualified immunity attorneys, because it was challenging. I think we went through, I don't want to go into all the process, but we had some challenges in getting the cases coded accurately, because they're really confusing, they're really complicated, and there's a lot to sort through.
So kind of getting out of that sort of more granular process stuff, what does this report show us about sort of what the road forward looks like, right? How do we fix qualified immunity? How has this changed how IJ approaches qualified immunity?
So I think what this report shows us is a pretty clear-eyed picture of what qualified immunity is doing, and that doesn't really map on to the debate over qualified immunity. If qualified immunity is a policy decision by the Supreme Court, then we should question whether that policy is achieving what it wants. If qualified immunity is about providing breathing room to police officers who are sued for excessive force, in over a fifth of the cases, neither a police officer nor a claim for excessive force is even present. So it's a policy that is certainly sweeping up a lot of things that have nothing to do with its justification. And I think that should give the court pause, and it should give judges pause in how expansively qualified immunity is being applied, and how far it's drifted from its actual stated justifications. And it should also give legislatures pause, both at the state level and in Congress. Qualified immunity is a judge-made doctrine, but it can be fixed through legislation, just as it can be fixed through the courts. And I think if we're going to have a debate about what qualified immunity is meant to do, that debate has to start with a serious look at what qualified immunity actually does. And that's really what this report provides.
Bob, let's pretend for a second that we live in a world in which I am a circuit court judge. Now, let's just shelve our...
I'm very happy in this world.
I am too. But let's imagine that I'm a circuit court judge and I get my hands on this report for the first time. Now, obviously, I'm not at a position where I can end qualified immunity myself. I'm bound by the Supreme Court's decisions in these cases, but I do have a fair bit of discretion in whether and how I apply qualified immunity to the cases that come before me. So what are you hoping that circuit court judge might do after they read this report as they continue to decide these sorts of cases?
So I don't know, actually, if I think this report would be news to circuit court judges, because as far as I can tell, circuit court judges are very frustrated with qualified immunity, with how it is applied, and kind of with what the doctrine asks them to do. So certainly the circuit court judges who are on the front lines are probably well aware that they see an awful lot of First Amendment cases. They're probably well aware that there are a lot of qualified immunity cases where the only defendant is the mayor, and there aren't any police to be seen. But I think the important thing for judges anywhere to do when applying qualified immunity is to take seriously the idea that there is a constitutional right at stake, that qualified immunity only comes into play when the Constitution has been violated. If the defendant didn't violate the Constitution, you can always say the defendant didn't violate the Constitution. The only time we need qualified immunity is when there's been a violation of the Constitution, and I think that should make all of us skeptical of how broadly we apply it.
Thanks so much for coming in to talk with us today, guys, and listeners, go check out the report.
Thanks for watching today's episode. I'll now respond to some comments from our previous episode about New Jersey's bizarre baby blood collection program. @Daniels writes, "The government is so creepy." Well, it definitely can be sometimes. @Clive KLG 7739 said, "Fourth Amendment violation, period." Couldn't have said it better myself. @Stridio1 writes, "Keep up the great work, IJ." Well, thank you, and thanks for supporting us. @Tom Hafley 7498 writes in with a question. "Isn't this a HIPAA violation as well?" Well, that's a great question. It actually isn't. HIPAA's protections are actually far less than what the Fourth Amendment requires. For example, HIPAA's privacy rule has an exception that permits covered entities to disclose protected health information to law enforcement without the individual's written authorization and without a warrant. In contrast, the Fourth Amendment demands more: a warrant or consent. Plus, this is not a situation where a patient has willingly given protected health information to her doctor. The state mandates the collection of the blood, and in some states, like Utah, the blood legally becomes the property of the state after the state takes it. If programs like that remain in place, HIPAA wouldn't even apply. Thankfully, the Constitution sets a higher bar. @You've Been Middled commented, "I can't imagine there was fully informed consent here." Well, you're correct. There was no consent whatsoever. And that's the problem with what New Jersey is doing. It tells parents that it's collecting blood to test for diseases, but New Jersey never tells parents that it will keep and use the blood after testing is complete. The goal of IJ's lawsuit is to change that. If New Jersey wants to continue to keep and use the blood, that's fine, but before it can do that, it must get real informed consent from parents. That means explaining to parents why it wants to keep the blood, what it wants to do with it, and how long it wants to keep it, and then let parents make the choice whether to opt in or opt out. @Jack Burton 2680 writes, "It would have literally zero effect on my life if someone had my blood. Pretty inconsequential thing to be filing suit over, especially when there's actual victimization occurring as a result of rights being trampled on." Well, I have to disagree with you, Jack, because this is what's great about the Fourth Amendment. If you're okay with the government taking and keeping your blood, you're allowed to consent to that. Or if the police show up to your house and ask to search inside, you're allowed to say yes. But other people may want to say no, and that's when the Fourth Amendment kicks in. Before the government can take your blood or search your home, they have to ask. And they have to ask even if you don't think it will have some lasting effect on you. But here, the problem with what New Jersey and so many other states are doing is that we don't know what effects this will have on people's lives. New Jersey is not telling parents what they are using the blood for, and by keeping it for decades, we don't know how technology will advance and allow New Jersey to use this blood in the future. You see, that's the really scary part. New Jersey is keeping highly personal and sensitive information without any transparency or accountability. Well, that's it for today. Thanks again for watching, and don't forget to subscribe and sign up to become a monthly donor of IJ.